Professor Berger really does not need any introduction. He is the director of the Division of Freedom of Expression and Media Development of UNESCO, and that is a position which is, I would say, a bit of a hot seat. I think we actually had a staff seminar earlier today, and we asked quite a number of pointed questions, and his answers show that he is very much on the ball when it comes to understanding how freedom of expression works or doesn't, as the case may be, around the world. Today's topic is possibly particularly poignant for Malta, because we are going to talk as well about defamation, online defamation, in this age of the media jungle that is the internet. I think it's an extremely important topic, and I can't think of a better person than Professor Berger to actually talk about it. Professor Berger, I leave it to you.
Mr. Ambassador and your colleagues in the Foundation, thank you so much for this evening, and particularly also let me thank the MAX, the School of Media and Knowledge Systems, is that correct? Science. Particularly the Dean, Professor Mary Brockdorf, Joe Tachi, and of course Prof. George Maria. Well, let me jump into the topic, which, as you said, is topical here. I think it's topical in many places. And I think defamation needs to be understood better by journalists. So it's fitting to be part of a foundation for improving journalists, but also to be understood by the public. So what I'll cover in this particular presentation is the following. I'll speak a bit about how UNESCO approaches internet issues, because it's a bigger approach. And I'll start off telling you a bit about that, and then I'll jump into the defamation side. And it's particularly speaking about how you can understand defamation in terms of human rights and how these different rights need to be balanced. Then I'll speak about, unfortunately, the many, many cases where defamation law is used to imbalance the rights and actually to violate freedom of expression. Only then will I come to the complications that the internet brings, because it's already complex before even the internet is invented. Then I'll speak about this UNESCO approach, ROAN, which is very simple, easy to remember, and how I think that can help in figuring out how to balance these different rights. So I started with this UNESCO approach, and I think you may know that UNESCO has, it's part of the UN system. It has 195 member countries, including your country, and it's very hard with all those countries to get agreement, as you can well imagine. But we did, perhaps surprisingly, get agreement in November last year by all the member states on this idea, internet universality, which basically means if you want the internet to be universal, one internet for everybody, you need to have a number of principles, which are these ROAN principles. And they're very simple. It says that the internet should really be respecting human rights, it should be open, it should be accessible, and it should have multi-stakeholders, in other words, many different constituencies involved, not just one. So just keep that in mind, because I'm going to come back to that later, and you can see how that is relevant to trying to get an understanding of defamation and its place in this ecosystem of the jungle that Prof. Maria was telling us about. Okay, so what we're talking about with defamation is really when human rights run up against each other. And in particular, we're talking about the expression, my right to express, but your right to reputation and in some cases dignity. And defamation is when the expression infringes on those rights. So the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, it says that, in fact, you can limit expression. It's not an absolute right. And you can particularly limit it for the purpose of respecting other rights and treatment of So does that mean that I can never do anything that impacts on your reputation or your dignity? Well, sometimes maybe I can, and this is the difficult balancing that has to be done. It has to be done in a way, according to these international standards, that it cannot be arbitrary. It should be done according to law, so defamation is usually a law, and that's good. It has to be necessary in a democracy. That means that you cannot limit rights just for an arbitrary reason or for a political reason or a personal reason. It must be done for the respecting of other rights in this case, but it has to be done in a way that is really necessary. In some cases, it may not be necessary to limit by a particular kind of measure that is taken. And I'm going to explain this a little bit more. So defamation, defamatory expression violates an individual right. I think this is at least the basis that everybody can agree on. Many people would like it to apply to other parts of society, but there's not agreement on those issues. About whether you can defame a religion, does a religion have a reputation? And these are debates that I'm not going to deal with now, because I'm really going to focus on what everybody agrees with, is each person has the right to human dignity and her reputation. And therefore we'll just limit the discussion to that. Now, Joe Kanatachi will be interested, of course, because I'm going to mention the word privacy, that defamation can violate privacy. Not necessarily, because not all defamatory remarks about somebody necessarily is a violation of their private life. And not all violations of privacy through expression will amount to a violation of your reputation. You may be a person who's donated a huge amount of money to a charity but has kept it private. I go and expose that to the public. I've invaded your privacy. But I haven't defamed you. Actually, your reputation is probably going to increase. So these are different concepts: privacy and defamation and reputation. But I think that one can make important distinctions between these. And how I would present this visually is like this: is that at the bottom of this triangle you have freedom of expression, and freedom of expression can directly tarnish the reputation of somebody and their dignity. But it can do it indirectly by invading privacy and making that private side of the person's life public, and through that means. So the one is direct and the other one is indirect. I'm just putting a slash there between violating reputation and dignity, but they're not quite the same. In fact, some countries have an offence different to defamation. They call it criminal injuria, which is a dignity. But I'm just putting them together at this stage. I think that's useful for our discussion. Let me move on a bit. So I hope that you can begin to see where I'm going. Let's look at this question of balancing rights. So in the philosophy of human rights, all rights are equal. No right is more important than the others. I have a job which is promotion of freedom of expression, so I guess you could suspect I'm biased in that direction, which I am. But nevertheless, I have to respect the international human rights law, which says that all rights are equal, and therefore you cannot put one up above the other. So the question then is, what do you do when they conflict? You have to resolve this somehow. My right to speak, your right to reputation. Now, when you're doing this balancing, what many learned people have said is that when you do the balancing, it should try and be a balance that preserves the integrity of each right to the greatest extent possible, and therefore the limitation should be as limited as possible. In that, you also have to make reference to public interest. You can't just limit for the sake of limiting. It must be saying what is actually going to be not just for the individual interest, but also for the public interest. And as you can imagine, that's not really so easy to decide. Then, as I said earlier, any right can be limited, but to be a legitimate limitation, it's got to be in law, necessary. And part of necessary leads you to this other condition of proportionate. In other words, you should not use a hammer to kill a fly. I'll give you more vivid examples when we come to defamation. And in a democracy. So these are very strict conditions, and why these conditions are important is because human rights should not be limited just on a whim. You know, in limiting a human right, expression or reputation, these are really serious things, and so you've got to put very tight conditions around when a right is going to be limited. Well, because of these conditions, if one had the exploitation of defamation for political purposes, that would not be legitimate, because the right to compete for political office is not a right that enables you to then go and limit the right to freedom of expression. Most use of defamation all around the world is by political people. And they're using it not so much to protect individual reputations, but they're using it for a political purpose. And that is not legitimate in terms of the international standards, but it's very common. Well, let's see when rights are violated through limitations that go too far. Now, what I've decided here, not my personal decision, but I want to make a distinction between the limitation of a right and the violation of a right. Because as we've seen, it's possible to limit a right under certain conditions and for certain reasons. A limitation is different to a violation. Okay? Because a violation is when you have an unjustifiable limit or an illegitimate limit that fails those criteria of being necessary, proportionate, and in law. Okay. Now, there are debates about, when we come back to the triangle of reputation, privacy, and freedom of expression, there are debates about whether defamation law really works to get a good balance between these, or whether defamation law can end up violating the right to freedom of expression. There are debates also about whether defamation law serves most often to violate the right to freedom of expression, more so than protecting the rights to reputation and dignity. And let me give you examples of this. So when defamation law violates these rights, the right to expression, in some countries people are put in jail for defamation. Some people go further and say you shouldn't even put them in jail at all, because jail is a pretty strict, a serious sanction. And again, perhaps there are other less severe options available to deal with the problem of defamation, which don't require prison. Examples that you could give are self-regulatory bodies, where somebody who's defamed can say, I've been defamed, I want an apology. That doesn't require an apology can be given voluntarily without requiring a prison sentence. Another one is that a person can go to court and bring a civil action, not a criminal action, a civil action, and get damages, or get an apology, or content taken out for those reasons. So these are possibilities which mean that it's not always necessary to take the most severe action. But unfortunately, some defamation law involves prison. To go further, there's another proposition that I could make, that criminal defamation, even when you don't have a jail sentence involved, even this can be disproportionate, because again, there are these other options. It's not necessary then to have a criminal case where a person will get a criminal record and the state must do the prosecution. If there are alternatives that are not quite as severe in the way that they may intrude on freedom of expression. But unfortunately, we do see that criminal defamation is still very common around the world, even in your country. The European Court for Human Rights has said, in principle, they do not think criminal defamation is illegitimate. But in many cases, they have criticized the application of criminal sanctions. They said this should never have resulted in that severity of a sentence. So, well, that's where they are, but they've got other views which I'll speak about shortly, because there's also impact on European Court for Human Rights and online defamation. But what's interesting here, I think, is that one could pose, and UNESCO does pose, generally speaking, criminal defamation all things being equal, is disproportionate. You don't have to criminalize a response to defamation, to stop defamation or to provide redress. There are more ways in which defamation law often violates expressions. When there's a civil case, the extent of damages is sometimes huge. It can put a particular media operation out of business. So the financial penalties can also be abused in this way. The next one is that even people would say financial penalties sometimes can be disproportionate, because sometimes your damage can be remedied by other measures which don't even require damage. Not always, but sometimes. And then there's another proposition that defamation findings, sometimes in some places they'll say you defamed irrespective of whether it was good faith or not. You have a case here in the history of Malta of journalists who are reporting about a particular case, and that case eventually went to the European Court of Human Rights. But the whole thing was, did the journalist intentionally diminish the reputation of another, or did they in good faith report information? And the European Court of Human Rights accepts a good faith defense, which is, it's an important provision, because when you're looking at what kind of sanctions are required for violation of rights, state of mind, doing things something with malice is important. It's sometimes difficult to prove whether there was malice or not, but that is important about whether defamation law should be applied and there should be a particular response. So, unfortunately, you also find in many countries defamation law is applied with no regard to the fact as to whether it was really intentional defamation or whether it was publication in good faith. And even more violations that do take place sometimes of freedom of expression. Sometimes journalists are charged for defaming the status of a public office. Now, I think you could agree that in a democracy, it's hard to separate always the occupant of a public office and the public office. So people, normally speaking, are not just insulting public office just for abstract office. They are defaming it because of the person in it. Okay? Now, this raises a lot of interesting questions. Is it a defamation that can be justified in terms of public interest? Is it defamation that's relevant? Is it a defamation that's perhaps more tolerable because it's in the political sphere? I know people often say if people don't like the political heat, they shouldn't go into the kitchen, because in public office you tend to be more open to exposure and you have to be more robust in terms of the kind of criticisms you may have. And then there's the insult laws, which are similar to this public office status, but it's actually in the law. And then a journalist will not be prosecuted under a defamation law, but under insult law. And this will also, these are also very much used to suppress legitimate political criticism on the basis that we have a law, you may not criticize whoever is in that office. And the last one that I've put here is that sometimes defamation laws don't take into account the difference between opinion and facts. And yet, you can make a strong case they should, because freedom of opinion in international human rights is really sacrosanct. So if I say, I like the president, or I dislike the president, that is my opinion. And that cannot be taken to be diminishing his reputation, or her reputation, or dignity. That's an opinion. If I were saying the president is a thief, that's a different story, because now I'm making an allegation and perhaps I've come with some facts to do that. Well, if the facts are there, then whether the facts are true can make a difference to whether it's a public interest defamation or not, you reduce the reputation or not. But unfortunately, not all applications of defamation law make this distinction between facts and opinion. Sorry, there are a few more. Have we nearly finished that defamation findings that don't bring in a public interest defense, where they can say, yes, I did reduce the reputation of that person. I did impugn their dignity through what I published. But I did in the public interest, and this is why. Some places do not accept that as a defense. And then we come to this truth question, which I just mentioned before. Truth, of course, is not always a defense. You may publish true information about a person, which may diminish their reputation. That's not always a defense, but certainly if you publish false information that diminishes their reputation, that is not going to save you if you're trying to escape some sort of liability for defamation. So, let's turn now to when defamation law is legitimately applied. And then we're going to come to the internet shortly. So when defamation law is not disproportionate, when it is applied as a last resort, when there are other options that are considered, when defamation law does not get mixed up in this insult law, when defamation law is not resulting in disproportionate financial penalty, then yes, defamation law can indeed be a legitimate limitation on freedom of expression. It can counter abuse because it can deter future ones and it can redress existing cases of violations of privacy and reputational dignity. At the same time, and to sum up what I've been saying, we need to be aware of the extensive problems of defamation law that essentially, although it's legal, it and its use are not really in line with international standards of proportionality and purpose. Okay, so how does all this play off in the online world? And this is, I suppose, the meat of now, the big debate today. We know, of course, that defamatory expression can be more ubiquitous online, because first of all, there's many more people expressing themselves in the public sphere. Second of all, there's a lack of awareness amongst amateur communicators in public about what is defamation. Journalists at least should have some training, some understanding. They should be a bit more sensitive to the issue. But now you've got a lot of new people coming in and they just don't know about these issues. Then it's also true that the internet is a realm where there is trolling, there is anonymity, there is meanness, there is hatred. There's a lot going on there. And in some cases, you could say the culture of the internet is not really a very civil culture in many cases. And so it's not surprising in that context that you do get more defamation. Another thing is that much online content stays online. The internet does not forget. And so defamation can continue, and it can of course spread much more easily on the internet. So these are some of the complexities about why I think people are concerned about the defamation online today. However, it is complex because of many questions. The first is the jurisdictional difficulty. Which state should protect you if you are defamed and if you do need to find a legal remedy? Okay? We have found in some countries, the UK in particular, there has been this phenomenon of defamation tourism, because until the UK recently amended its laws, people all around the world would go to UK courts and say, this content that's online, it can be downloaded in my country, and it is defamatory of me, whether it was downloaded or not, to what extent it wasn't really considered. And they got a very good ruling in the UK court, which then would be enforced back home. So that was a bit of an abuse of it, but it shows the complexity. Evolving practice now is in this international arena to say, okay, let's not say just because online it's relevant all over the world. Let's really look, where is this being first put on the internet, and where is it really targeted? Where's the audience base? And limit that, because if you're going to say it's on the World Wide Web, and therefore I'm besmirched in terms of the whole world, that's not really that convincing or realistic. But there was a time when courts in the UK were really accepting And I think there's also now, in legal practice and these issues, people are beginning to realize that the internet is a bit like the political kitchen. It's not good, but it is also, you need to know, it's not a place for sissies. You go on the internet and, you know, if you don't go on, but it's a place where, as I said, it's not particularly civil. And so, in a sense, do you accept it? No, but do you have to live with it? To some extent, yes. Now, the complexity of remedies on the internet also is that, if you take one example about, say there's a defamatory comment about you on Facebook, who should be liable for this? Now, it used to be fairly easy with the newspaper. The reporter was liable, or the publisher was liable, or both. Now, when you come to the internet, is it Facebook that's liable, the company? Is it you, the person who's put that up there? Sorry, maybe that didn't make that much sense, but it depends. If you put a posting on Facebook that is libelous, is the person who commented under your post, you know, like or dislike and added a comment, are they liable? Should you have taken down their comment on your post? What if somebody links to your post on Facebook? And how does their original identity be tracked down? This makes it very, very complicated to find a legal response to defamation, because you've got so many layers here, as you can see. There's another debate in this thing, which is when is an internet platform a neutral conduit and when is it media? Because media generally, it is accepted that media has a responsibility for most of its content. It's certainly that it emanates. But internet intermediaries, normally speaking, are treated as having limited liability. Okay, that means particularly those ones who are not crafting the content themselves, but just carrying it or making it available. It's not their content. They can't really hold them liable if it wasn't theirs in the first instance. Now, what's interesting, the European Court of Human Rights did actually say in a case called Delphi that an internet intermediary company was liable. They should have actually seen that this company was, they should have pre-screened it, in fact, before it was put up there. That's an interesting decision that they came to, because it really goes against a lot of principles that you should face the consequences of speech afterwards rather than be pre-controlling speech. And also it goes against this neutral conduit model for internet companies. But interestingly enough, there was a new case just last month at the European Court of Human Rights based on libel in online media in Hungary. And Hungarian courts found there that the internet company was liable. And went to the European Court of Human Rights, and the European Court of Human Rights said, actually, we don't accept, in this case, that they were liable. They said one of the reasons why we accepted liability in the Delphi case is because the defamation there was also hatred, hate speech. It was a call to violence. This case in Hungary, it was an opinion. Now, as you know, opinion is not the same as facts, it's not the same as incitement. So that's why the European Court of Human Rights said, well, we don't hold the company liable in Hungary for defamation on there. They said it is defamatory, but they also raised some other things. First, they said it's an opinion. Second, they said the company has a very clear system that people can alert them if there is problematic content in the company, can then take it down or not take it down. If they don't take it down, then they become liable. But otherwise, they do have a clear system. Thirdly, in this Hungary case, the European Court of Human Rights said the actual damage, the reputational damage, was very minimal in this case. In fact, it was a company that was complaining, and the company already had a very bad reputation. So you couldn't really reduce the reputation even more. So that was the judgment. And there was a fourth point that they made, which yes, they said that the Hungarian court had simply decided to find the platform responsible for the defamation, and there had been no pursuit of the actual author of the content. And they said that was a mistake in the Hungarian court. So we have two different rulings to summarize. The one is, the European Court of Human Rights said, in the case of Delphi, the intermediary is liable for carrying defamatory content because it was also inciting to violence. In other cases, they said intermediary is not one. So we have interesting criteria there. Well, to come into this, I'm going to start winding up now, so if you feel confused about the complexity, don't worry, we're reaching near the end. But there is a question about what point does liability kick in, and this was brought in to this case of this Delphi ruling, because actually the Delphi company, when it was brought to their attention that they had this insightful defamation, they took it down. But that wasn't good enough for the European Court of Human Rights. They said Delphi should have been pre-screening and never allowed this thing to see the light of day. Now that is pretty kind of severe, because you know these social media platforms, they are receiving floods and floods and floods of content. And so what happens? I mean, are they supposed to really check every single one before they put it online? And I think what this really points us to ultimately is a grave danger that intermediary companies will become risk averse. In other words, anything. They might introduce an algorithm, and any word that says so-and-so, they'll look for the word pig. Anybody who, they'll do automatic search, any posting that says use the word pig, they will then delete just in case it's defamatory and the person will sue them. They'll do that in advance because they don't want to be, punished. Or even if they've brought to their attention, rather than looking at the merits of it, they might say, oh, well, let's not face any problem, let's take it down. And this actually happened in one case in South Africa. Somebody was criticizing a company, and the company went and complained to the internet provider. The internet provider took it down, irrespective of whether the merits of the criticism were justified or not, and didn't even tell the people who produced this. Okay, so how does one try to balance these things? And I come back to this row, and well, we have all these different rights online. And you remember that triangle that says internet should respect rights. The problem now is we have different rights. How do you respect all these rights at the same time? So how do you balance these rights online? First of all, I think we can recognize that the balancing act is not only an act for the states to try and figure out a balance with the courts, it's also for these intermediary companies. They've got to figure out how they're balancing these rights, the right to expression versus the right to privacy versus the right to reputation. And users themselves need to start to understand this more. Just as a slight detour, but I think this is an interesting discussion that we may have, is that some people say the problem with the internet is there's too much anonymity. And anonymity is feeding this defamation, because people think they're anonymous and they think there are no consequences, therefore they can defame without any hesitation. We need to be very cautious for limits of speech, and so alternatives could be promoted when there are cases of defamation or alleged defamation. So if an internet company receives a notice that says, that's defamatory, take it down or I'm going to sue, they could say, let us send your complaint to the person who put it up. And they can decide if they want to take it down. If they don't take it down, of course, proceed. Maybe we'll take it down, and if we don't take it down, because we think it has a right to exist, then you could sue us as well. But you could have a notice and notice, rather than notice and quickly take down, which is the current system. The other one is a right to reply. And in a way, these can be more proportionate responses. Instead of limiting the speech by cutting it, or bringing a court case that's going to impose heavy penalties, there are easier remedies. To come to the third area, accessibility. People have access to the internet, but by accessibility, what UNESCO wants to speak about is the literacy. They have media and information literacy, so that people can begin to learn more about using expression in ways that don't do this. This really, I think, is super important, that even in the schools, young people need to start learning about what is the right to reputation, what is the right to expression, how does the right to expression, under what conditions can you reduce a right to reputation? It's under very tight conditions. Under what conditions can expression be limited? Very tight conditions. And this literacy is also needed. So when there are not state remedies, because it's very different in the internet to have a state remedy, because it could be, the actors can be far away, the company can be far away. that at least the users can then identify and say, that's defamatory, that doesn't seem to have any public interest, that's, those facts are wrong. And they can counter it. And in a way, I think we have to start to rely a bit and try to change the culture on the internet so that the majority of people start saying, defamatory speech, we don't like it. We don't like the violation of reputation. There's no place for that here. It's not in our community. And lastly, I think this is very important, the multi-stakeholders discussion, which basically means that if a company is developing a policy, if a school is developing a policy, if a government is developing a policy, really to involve all the different actors, because no single actor can control this thing. We've got all these different layers. You need companies involved. You need academics involved. You need governments involved. Of course, you need the judicial system involved. You need the users involved, civil society. Because only when people are beginning to put their different wisdoms together can you begin to try and get a good balance for this thing. So to conclude here, I think it's a very complex triangle of issues: expression, privacy, reputation, and dignity. I think there have been huge risks worldwide that defamation law has really violated expression. And it becomes very complex when you're addressing legitimate defamation, not the illegitimate cases. I think that this road model of recognizing, first of all, that the rights be balanced, second, we're trying to say, let's try and keep open as much as possible. Let's try and make it accessible through media and information literacy and empowering the users. And lastly, the multi-stakeholder. I think that gives us a way to try and approach these things. And essentially, it's ultimately about how to avoid reducing the internet as a universal phenomenon and its potential. How to avoid that as a result of fragmentation. Because you could have a one scenario, every government saying, we're going to block the internet at our borders precisely so we can enforce defamation law at our borders. Or they're going to say, we need to have, only when we have relationships with other countries can we actually enforce some defamation regress. Well, I think that those scenarios are not necessarily the scenarios that are going to keep the internet as a broad resource for everybody. So we've got to ultimately try and develop the norms whereby the way people behave on the internet is aligned to international standards. And the way that defamation law is applied, where it can be applied on the internet, is also aligned with international standards. And it's not disproportionate, but it is for good purpose, but it is actually spelled out that companies applying their own policies, those policies are in their own terms of service, so it's known in advance, it's not something that people are experiencing. So that's it. Thank you very much.